contribution for part-time, and this is just a rule of thumb, is 60% of the hours that the person might have put in before, 60% or 1,000 hours. That's sort of a formula that says, and we took this on advice from consultants, that going into this, we should insist on something like that sort of contribution from an individual. So it usually means 3 days, the equivalent of 3 days a week. It could mean less than that, and every one of these cases is looked at on an ad hoc basis, the merits and circumstances of the particular individual in the particular case, but that's the general rule and guideline we go with. We also, in terms of salaries, take the position that the contribution, the salary, would reflect something less than an arithmetic reduction in the hours that the person would be employed in recognition of the reduction in contribution to overhead of the firm. That's a general guideline to ensure that the arrangement is of economic benefit to the firm in the long run. The policy is a 3 or 4 page document. It's been in place for about 8 months now. I was very pleased that it went through the firm as easily as it did, and that the part-time people that we have in place at the present time are considered to be functioning well and in the interest of the firm, and the feedback we're getting from them is that they're very happy with the arrangement. I think, and I'm very hopeful, that this will demonstrate within our firm and other firms the viability of that sort of concept, and will lead us to doing more alternative work arrangements and experimenting with different ways of ensuring that we continue to have a supply of people who are talented and who wish to, at periods in their life, reduce the workload in the professional arena. We as a firm have had many different alternative work arrangements so far as staff are concerned, but have probably been as traditional as any other firm so far as professional people are concerned. And I think at the moment, with this demonstration, we will have the opportunity to look at other similar arrangements. That's the part-time presentation. Nancy is going to deal with the Women's Issues Committee and the other issues, and we'd be happy to talk about either of those things later on.
Let me offer 2 comments on what Bruce has said. Firstly, I'm of the view that to have a written policy, such as our part-time policy, in writing is going to be most beneficial to the women lawyers in our firm or other firms. I believe that in almost all cases it's better for women to have it in writing, that if it's simply an oral policy, that the experience of women will be that it will be interpreted on an individual basis, potentially in a way that's not beneficial to them. The other thing I'd like to say about our part-time policy is that Bruce mentioned that we had, at the time when the part-time committee was set up at our firm to inquire into this matter, we had some lawyers, a few lawyers working part-time. That's true, but there had been very much a controversy in our firm as to whether family-related reasons for wishing to work part-time was an acceptable reason for going part-time. There had been little controversy over persons who wished to work part-time for health problem-related matters, for the purpose of serving a client on a part-time basis and working at the firm on a part-time basis. But as a practical matter, the firm had more trouble with a request to work part-time when it was to look after young children. I personally found it hard to distinguish from the firm's point of view, from their interest, why there would be a differentiation. And we managed to persuade the firm as a whole that family-related reasons were an acceptable reason to go part-time, and that is part of our written policy. So I think that's one illustration of why a written policy will be beneficial, that there can be these sort of implicit, subconscious ways of differentiating between various requests for working part-time that will not work to women's advantages. Bruce and I were asked by the firm when this problem of women lawyers leaving our firm had become apparent to sit on a women's issue committee and to meet with the women partners of the firm to inquire into what concerns, what areas of concern were of particular importance to women so that they could be addressed. And I recall discussing this over lunch with one of my friends at another large downtown firm, and her comment was that she was very impressed that my firm would do this, that at her firm the attitude was when women left, the response from her male partners was, good, I hope the rest of them go too. So I took some sense of optimism that it was being seen as a problem and that there was some desire to try to look at the problems and remedy them. Having said that, I think it would be very misleading to suggest that we have all the answers or that we've cured our problems and this is a how-to to alleviate the problems. It's a pretty complicated, complex situation, and I think it's fair only to say that we've started out on a long process of identifying the problems and that we're taking steps that hopefully will alleviate, if not cure them. When we met with the women partners at my firm, the first area of concern that was raised, which was interesting to me, was a perception among the women partners that there was a compensation problem or disparity between the women lawyers and the male lawyers. I don't know why this really should have surprised me. I try to keep fairly current with literature in this area, and I guess I felt somewhat naive after having this meeting to find that this was something that was affecting us right here in good old Toronto. The views of my women colleagues were that the disparity or perception of disparity was in part a result of the impact of maternity leave. The opinions expressed were that until women were reaching partnership level, there was not any concern or feeling that there had been any disparity between their male counterparts and themselves, but that where they were being impacted was at the point where they were starting out at the junior ranks of partnership. And quite often that was commensurate in time when they would be about to go on their first maternity leave or would have returned from a maternity leave. The other perceptions about the compensation issue were that in some cases women were being, for whatever reasons, ending up practicing in areas of the law which were less lucrative to the firm than, say, corporate or banking or the more traditional legal areas of a corporate law firm, and that because their particular area of law was less lucrative to the firm, that was being reflected in the incomes for the women lawyer. There was also some women of the view that they were having less client exposure throughout the course of their legal career, which was resulting in them sort of taking a sidelines part in the practice of a particular client or clients, so that they would be getting less client exposure, which would mean they would be not involved in client in bringing clients in and marketing, and that would have an impact on their compensation at the partnership stage. What was recommended by our committee as a result of these concerns were, firstly, that there be a publication of what the compensation policy is. It seems to be the case that in the large firms, and I'm not sure that it differs from small firms. I spent 6 years in a 6-person law firm, and we had no written partnership agreement, and let alone a written compensation policy. So I doubt if it differs too much in the smaller firms as well, but certainly in the large firms, it's unusual for them to have a written compensation policy. And again, I'm of the opinion that where something is not written, this may well have an opportunity to work out in a way that's not fair to women. So that was our first request, that we know what the policy was, that it would be in writing, that we could refer to that then and have guidelines that we could point to if we felt we'd not been fairly dealt with. We secondly asked that the share committee of our firm do a blind test gender bias examination of the distribution of the points, which is how the partners are compensated in our firm, which I think is fairly typical for the ways in which partnerships are set up, to ascertain whether there was gender bias in the way in which they were distributing the points. We finally recommended that if the problem was seen to persist, that we bring in a professional consultant from outside to evaluate the point distribution system for gender bias. The second area of concern that was raised by the women, I think it was interesting that money was seen to be, the worst problem and number one problem that women were facing. The second area was the issue of maternity leave, which I think relates quite significantly on the compensation issue. There was very much a concern that women were being penalized not only in the year in which they were taking maternity leave, but that their careers were being somewhat put on hold, that they were going onto a slower track, that their compensation, that they were never catching up with their male colleagues, notwithstanding that they had come back on a full-time basis. And there was certainly a readiness to concede that for the year in which they took maternity leave as partners, that there was a sense of justice if their compensation reflected in some degree the fact that they had not been there for some portion of time, provided that once they were back, they were put back on the basis of as if they had not been away. So the recommendations that were made with respect to maternity leave was, again, that the maternity policy be in writing, because it was not. It was an oral policy, and that there be particular attention paid to financial recovery upon the partners returning to work on a whatever basis they return after the leave, if they take a leave. Again, this was seemed to be a problem that affected partners as opposed to women associates, at least on a financial basis. The women associates at our firm are given a 4-month paid maternity leave, and they come back and are paid commensurate with their male counterparts as if they had not been absent. It's a more subtle thing when you come to the partnership level at a firm, because the point distribution system is a somewhat subjective compensation system. The third area of concern that was raised at our meeting with the women partners was a concern about practice issues. The first being a lack of mentors for women lawyers in the firm, which was seen to have some effect on their overall career development. Bruce has talked about how 10 years ago there were 2 or 3 women lawyers in our firm. It's certainly the case that in all of the large downtown firms, there's a lack of senior women role models to look to as a mentor, to pattern your career by, or to provide support to you on areas that are of particular concern to women. One of the ways in which that affects women lawyers is that there is a lack, I think, of mutual support systems for women lawyers. There's a tendency for women lawyers to feel isolated in their practice, to feel that they're sort of outside of the mainstream of what's going on in the large downtown firms. Male lawyers have a sort of an informal network of lunches, golf, squash, dinners at home that women seem to be excluded from. And it was interesting at the meeting that we held with the women partners that it had not really been seen as an issue that affected women lawyers as a group. Rather, it had been seen to be something that each individual woman had faced during her practice, that she had felt it had some impact on her career. I think the impact can be something as subtle as discussions over lunch of issues that are of particular concern to male lawyers, and therefore legitimacy given to those issues, where women not having those informal contacts therefore are isolated, and there's a failure by the firm as a organization to be sympathetic to those issues. I think another impact of the mentor problem is that work assignments the better work assignments are sometimes or often given to lawyers who the senior mentor feels comfortable in dealing with, someone who he has lunch with, someone who he plays squash with, and that can be something that excludes women lawyers. These things are subtle. It's extremely difficult to come up with suggestions to mandate who you have lunch with, for example. And we simply identified those factors as areas of concern, and I think as women are taking more senior positions in the law firms, we have to be aware that for women coming behind us, that these will be problems for them too, and to try to play the role of mentor to them. I'm getting the hook here from Diana. Let me just very quickly say that the other areas that we dealt with in our committee were the issue of partnership admission, whether there was a disparity between the ease with which, as we've heard earlier today, mediocre males made it into partnership, whereas mediocre women would not. We, as a bottom line on that problem, recommended that a professional consultant, if the problem was seen to persist, come in to examine the firm history to compare the admission of men vis-a-vis women to partnership. We recommended that the committees of the firm, the governance committees of the firm, be more representative of the firm generally, and in particular representative of the women. And finally, we recommended that there be an annual review panel so that when women are having problems, they can come to this panel so that the problem doesn't need to be dealt with by them making a complaint to the appropriate governmental body, but it's not seen only as an individual problem, rather as a firm management problem. And that it will be up to that panel to make the appropriate inquiries and report to the management committees of the firm. That's it.
final speaker before we hold our panel is a visitor from New York City. This is Henry King. He is a member of the New York State Bar and a managing partner of the firm of Davis, Polk & Wardwell. He is president of the New York State Bar Association and member of the House of Delegates for both the New York State Bar Association and the American Bar Association. Mr. King is also active in a number of other groups, including the Executive Committee of Columbia University and the Executive Committee of the Lawyers Committee for Civil Rights Under Law, a nationwide group of lawyers appointed by President Kennedy in 1963. Mr. King is going to speak to us about his U.S. experience. Thank you.
Thank you very much, and good afternoon. I think my job today is to give you the experience of my firm as a case study in how women in the profession can gain status and advancement, and how part-time work can be utilized to assist both the firm and the lawyers involved. And perhaps the best way to go about this is first to describe the profile of our firm, and then give you the programs and why we think they are acceptable programs. We are a large firm in New York City, one of the largest. We have a total of 380 lawyers. At last count, there were 113 women lawyers. We have 98 partners. We maintain and try to maintain a ratio of partners to associates of about 1 to 3. This is historic. It is the typical pattern of New York City firms. I have to say it is not the pattern of many firms throughout the rest of the country, but it is true in New York. And I think for the foreseeable future, we would try to maintain that ratio. Of the 98 partners that we have, only 8 are women. But I have to describe the demography of the women in order to explain that. As I said, we have 113 women lawyers, 8 are partners. That means 105 are associates. Of that number, only 5 are in a class before 1982. We generally make partnership decisions after about 7 years. So the class of 82 forward, which has 100 women in it, will be coming up, the class of 82 will be coming up the end of this year for partnership consideration. And I think as we go along in the firm, there will be many more women partners made, recognizing those numbers. January 1st of this year, we made 6 partners, 3 were women. We hire about 60 new lawyers each year. This has been the numbers that we've been taking on in the last few years. We've been making partners at the rate of about 5 or 6 a year. Now, what happens is that in that 7-year time period, a lot of lawyers leave the firm, men and women, and they leave for various reasons. Very few are asked to leave, very few. Many leave because they don't like big firm practice, they don't like the big city, they're trying New York and they want to go home to their other cities or go into smaller firms. Some are attracted into our corporate clients, either on the law side or on the business side. Some go into government. So that by the time partnership decision comes around, there are probably 10 of the 60 left. And this attrition applies equally to women as to men. In the case of women, there is another phenomenon that I think just has to be recognized, and that is that there are some women who leave the firm even though they don't want to, because they're married to a professional or married to a business person who himself is transferred. And I can tell you the fact of life is that a woman is more ready to leave her job to go with a husband than vice versa. That is just a fact of life, and that has been the case in our firm and in most of the other firms in the city. It doesn't happen very often because in most cases, both working spouses are working in the city. But it happens from time to time. Some lawyers leave the practice, and I think some women leave the practice because they look upon big firm practice as involving sometimes running down every rat hole of spending a lot of time on detail. And, you know, they're comparing that kind of pressure and work on what are really non-essentials to, on the other hand, having a family or a different kind of lifestyle. And we do lose men and women because there is that kind of phenomenon in the big firms. Now, this is a problem that we have to address generally. It's not a woman's problem only. It is a general problem in the practice, the lack of civility among lawyers, particularly on the litigation side, and the fact that enormous efforts are made to cover every single little thing that could possibly arise in a litigation, almost to the exclusion of keeping your eye on what are the essentials and what are the jugular issues. So with that background, let me turn to the programs that we have. We have had a part-time work program for women for a long time, and it's been in writing for a long time. A woman who has a baby is entitled to 3 months total leave with full pay. Most women usually tack on their vacation to that. We give vacations of 4 weeks for the first 3 years in the firm and 5 weeks. 4 weeks for the first 3 years in the firm and 5 weeks thereafter. So women having children can add 4 or 5 weeks to the 3 months with full pay. Thereafter, women are encouraged to think about coming back to the firm either on a full-time basis, which some do, but also on a part-time basis. We are entirely flexible in this respect. Women can choose their own work schedule, and oftentimes it depends on the housekeeper that they have, what kind of child care they can provide at home. And some women can come in 5 mornings a week, some 5 afternoons a week, some 3 full days a week, and we leave it to them. We do not stipulate a minimum number of hours, but in most cases it is probably at least 50% of the time, because it is not really worthwhile for them on a shorter basis. And what we do is we compensate those part-time associates on the basis of a pro rata share of their class's compensation. Now, let me explain. In our firm, we have a lockstep compensation system for associates as well as partners. And that means that every year, every person in every class moves up the compensation scale, with very few exceptions where there is clear evidence of non-performance. So that somebody who is in the third year and moves to the 4th year moves up automatically, whether part-time or not. The pro rata is based upon a 2,000 billable hour a year, which is about our average for our associates over a long period of time. And we compute this on a quarterly basis for the part-timers, so that in one quarter the person may have worked 55% of the time, and another quarter 45%, some quarters 60 or 70%, and we compensate on that basis. We do not get involved in trying to evaluate whether or not that the part-time person is making the contribution and is entitled to the salary level that a full-time person is. And I understand that the previous speakers did mention this. We have not done that because we think that the difference to the firm in terms of dollars is very small. To try to make those distinctions creates problems, and we just don't think it's worth it. Some part-time women come back full-time. Some have another child and decide that they want to take some time off to have their children. It's about 50-50 of those who come back full-time and those who leave the practice, at least temporarily. We have, as I said, a 7-year time track for partnership decisions. In some firms, if you're not there in the 7th year, you lose the opportunity to become a partner. We do not have that in our firm. The 7 years is an average. Some make it in 6, some make it in 8. And in the case of women who take time off, either an extended leave or part-time, we allow them to stay on the partnership track even if it takes longer. And we've had 2 examples of this recently where two women have become partners after 11 years. And in both cases, they had 2 children while associates. In both cases, they took extended leaves of absence and came back to the firm and became partners. Even though, as I indicated earlier, very few of our associates end up as partners. These people did. We have installed computer terminals at home to make it easier for only for part-time workers, by the way, to make it easier for those people to get home and draft on the computer and have it printed out in the office. And this has been very welcome on the part of our women employees. We have done the same for men. We have not had a request yet for paternity leave. We would grant it if asked, but we've had 2 men in the last 10 years come to us separately to say that they were serious musicians. One was a composer and one was a performer. And they, in both cases, said they weren't sure whether they wanted to be lawyers or musicians. Could they work part-time? And we allowed them to go into that program. After a couple of years, they decided that music was not for them, and they came back on a full-time basis, and both of them became partners. So I think we have that kind of flexibility. We also have, and this is somewhat of a women's issue, but though by no means totally, we have partners married to partners, we have partners married to associates, we have associates married to associates. Very, very few firms allow that. There are problems, but we think that when we have talented people, we don't want to lose them because of marriage, and so we have not said no, as so many other firms have done in cases of that kind. And the result of this is that we have, I think, gained a certain amount of respect in the law schools. It, from a very selfish standpoint, has helped our recruiting, not only among the women, but a lot of men look upon this, and we've gotten some notoriety about these programs in the law schools. Men look upon this as, I hate to use this word, somewhat enlightened view of life and the practice, and we have attracted some very, very good people to the firm in just the recruiting. I might say there are other reasons why we have done this part-time program and have maintained flexibility. We spend a lot of time recruiting. I mean, we go to 20 law firms, we have large committees of partners and associates. We spend hundreds of thousands of dollars, literally, in sending people out, getting people back, paying their way to New York, entertaining them royally, trying to get the best we can. And we think we do very well in recruiting. Those people become enormously valuable to us in the 2nd, 3rd, and 4th years. It's just at the time when they may be leaving, when this attrition starts. We don't like that. We've spent money and effort to get them into the firm. We would like them to stay for a longer period of time. By providing part-time work and the ability to have children and come back, we are helping ourselves. The value of a part-time associate is good. It's not perfect. There are times when you would hope that they were around all the time. But I can tell you that most women have told us that if we want them to travel, they will travel. Just give them a little notice so they can arrange for their housekeepers. If they're in the litigation department and they're going to trial, they want to be in trial all day long. They don't want to miss that experience. But they can plan for it because you know when the trial is coming up. And so for 2 or 3 weeks of a trial, they'll be working full-time and longer, and then take more time off when the trial is over. And we have seen this because the person wants to develop, and going to trial and participating in it is professional development. So those are economic reasons why we think that it is wise. But I have to say there is an additional reason of basic fairness. The 7-year time track to partnership coincides with the biological clock for having babies. Not totally, but there's a strong overlap. And I think that if we're going to have 40% of the women in the United States as part of the law school population, and we're going to try to, and they are oftentimes represent the top portion of the law schools. And if we're going to be recruiting those people and getting them into the firm, it is only fair to give them the opportunity to do both. And it is not only because I'm married to a lawyer and have a lot of children. I really think that it is the fair way to proceed. And in fact, there was never a question in my firm about this. I'd be glad to answer questions in the question and answer period, which is coming up, but I think that covers the essentials of Davis Polk's experience. I should add that we are not the only firm that does this. I think New York has probably led the country in these programs. We seem to be a little less stratified and a little less conservative in that city. Washington is very close behind, and in some instances have done more than we have, some of the large firms. But this is spreading, and the idea of part-time work is now accepted in most of the large firms throughout the country, and certainly in the big cities.
Could the other speakers come and join us up here, please? It's a little bit of innovative scheduling here. We're going to try and do two things at once. One is to have the panel and give you an opportunity to ask questions, and the other is to have a wine and cheese party. So the wine and cheese will be wheeled in momentarily. You're wheeling. Or the answer. So if you feel free to wander up and help yourself when it gets here and ask questions of the panelists. The panel is going to be chaired by Joan Lax, who is Assistant Dean at the University of Toronto and a member of the Planning Committee for this continuing legal education program, and everybody else you now know.
I'm hoping, the wine and cheese has just been wheeled in, so I'm hoping that you'll each go up and have some. Maybe we should just take a minute or two now to allow you that opportunity, because it might be awkward to get out of the chairs, and we are a little bit ahead of our time schedule, so we do have the time. So I invite you to help yourself to some wine and cheese, or cheese and or wine, or whatever combination you prefer. Go ahead. Thank you.
We have had several women partners have children, and they have taken the leave, which is the same for partners as for associates. Both, in 2 cases, we've had that, and both came back full time. So we have not had the request for part-time partners. I think we probably would say yes to that, at least for a period of time. If a woman came to us and said, I want to work part-time for years, I think we'd have a problem with that, but we haven't been faced with it.
Maybe I could ask why that would be problematic on a long-term basis when it's not problematic for the first 7 years of a lawyer's life at your firm.
Well, I think we look on our partners as extremely hardworking and high performers. We try not to make any differentiation in compensation to them. And I think that over a long period of time, as a partner with client responsibilities, it is very, very difficult to be part-time. It is possible as an associate for a period of time without losing your right to become a partner. But I think over an extended period of time for a partner, it would present a different kind of a question for us.
Do you want to follow up with that?
Yes, I just wondered if we could get a response from Fraser and Dee.
We have. We currently have women partners on part-time, and in fact, when we set up our part-time committee, that was one of the issues before it, whether a partner who wished to go part-time could retain their partnership. It had been, I guess, the case with the one woman partner that we'd had who wished to go part-time. She was asked to resign her partnership. That was the terms that were proposed to her when she chose to go part-time prior to our having this committee set up. Our written policy does apply to women applies to all partners, and it does not necessarily require them to give up their partnership. So it's something that is to be looked at on an individual basis.
I just take it from the comments you made, Mr. King, that your partnership works in a lockstep arrangement, I think you said, and I gathered, at least by inference from the comments that you and Bruce made, that your partnership does not work in a lockstep arrangement. I wondered if that might account for the different policies.
I don't know, I had a comment on that. I know your lockstep compensation arrangement for associates, and ours is lockstep for 3 years, and after that there is some distinction. But I wasn't sure when you talked about lockstep for partnership, what you precisely meant.
Partners go up each year. They're increased in points by class, and we do not make distinctions within the class. Now, we have 98 partners. We do reserve to ourselves the right to hold somebody back who has demonstrated non-performance over a period of time after warning. I am the chairman of my firm, and I'm on the compensation committee of the firm, and I have to apply that, and in about 10% of the cases, we have held partners back, at least for a portion of the time, until they've responded to the problems. And in almost every case, it is unwillingness to work, to be cooperative, to help other people. And after warning, and if they don't respond, we will reserve the right to do that. And it's very public. All the partners know it. And so there are very few who are not responsive. Other than that, everybody is lockstep. Everybody's lockstep all the way to the top.
Ours is not like that.
No. Yes?
I have a comment to make rather than a question. I've been quite awestruck that although this, first of all, let me say, for those who come from a psychologist, human data field, I've appreciated having that information, that those in the legal firms or related businesses, I've been struck by the fact you keep talking about adjustments to bring women in. Although I heard, decided, Nancy, and your stuff about networking with other women partners and so on. I want to know what those firms are doing to help men readjust. You keep talking about, one of the statistics we heard that women are out on, I think, a 1983 stat, were only out less than 2.5 months on maternity leave. And yet, paternity leave is coming in for 10 weeks in this country, and what the heck are the men's morals, values, and attitudes towards equality? What's happening in the firms around them? Because it seems to me making organizational adjustments in firms is just a flick off the iceberg. And it seems a simplistic approach to dealing with a mammoth shaft, if I may put it, that keeps women continually discriminated against in the legal profession.
I don't know. Bruce, you're the only man. I guess you're going to have to respond to this.
I'm not sure. I'm not sure. I'll jump in.
And Bruce, for example, you sat up.
Bruce, you got it.
The only one you wanted to talk to of any of us in this room is Mr. King. And as a seminar on women in the legal profession, that was a pretty weird thing for a woman to hear, just to call you on publicly.
Okay. Yeah. Well, I was impressed that Mr. King had taken the time to come and speak to us, and I was very interested to know.
So did I take the time to come and listen to you.
Let me try. I'm not sure I understand the question fully, though I get the import of what you're suggesting. If what you are suggesting is that there is a lot of room for improvement, you're absolutely right. We've come a long way. There's a long way to go. There are subtleties of discrimination that are deplorable. We've tried to address it in the organized bar, in the courts, and so forth. We hope that those things in time will go away, but they have to be talked about, and some of us have talked about them. There are also some structural problems, apart from the overt sort of discrimination problems. There are structural problems, the glass ceiling concept, and so on. I think that there's a long way to go there. In describing my firm, I'm not saying that it's perfect. It's good. It's not, but far, far from being perfect. And there's a lot more that can be done. Perhaps in the area of partner part-time, perhaps in the area of child care, although that's enormously difficult in New York City, and even greater flex time. But I think that if you talk to the women lawyers in our office, you'll find it's a pretty happy lot. And it's not because they're being discriminated against as women. It's because they feel that the firm is a decent place to work and that they are treated as humans. By the way, when you talk about men, I think that a point I made in my initial remarks, I think may be worth repeating. There are problems in the law generally. I mean, I'm active in the New York State Bar Association, and I see this there and throughout the country. I talked about the lack of civility. This is a serious problem. A lot of bar associations have come up with codes of professionalism that are applicable to men as well as women. There has to be some humanizing aspect to the practice, and I would hope that women would play a role in that, but it applies to men as well, and to the extent that is so, I think it makes for a better profession for everybody.
Goodness. Okay, yes?
I have a question for Nancy or Bruce. With the part-time partners in your firm, is there a limit on how long they can work part-time? And my second question is, how do you deal with compensation for those partners? Is it a written policy?
Firstly, with respect to a time limit, the policy provides that partners and associates will be dealt with on an individual basis, so that each situation is looked at based on that particular lawyer's circumstances. It is not the intention of the policy that there be a time limit to it. So it provided it's economically feasible to the firm, it's expected that it can continue so long as the lawyer is interested in continuing it.
Sorry, Nancy, just one point. Although it may continue for a period of years, it's supposed to be reviewed annually in terms of looking at the relationship to see whether any adjustments need to be made or whether it's operating satisfactory. And that's seen as an opportunity to simply sit down and have a check on how successful it is.
Bruce, I'll let you address the financial part of the question because you're more familiar with it.
Well, the financial part of the question is really that we don't have a specific policy. It's looked at in terms of the contribution of the individual and the contribution and the firm's needs at that time. And it will differ depending on the individual, the type of specialty or the type of practice that they have, and the needs of the firm at the time.
Yes?
Just following up on that question, how do you factor in or deal with support services like
things, and I guess this kind of echoes with what Henry has just said. There's still a lot of unfinished business in terms of our reviewing our part-time policy and ensuring that we've got a policy that we can live with permanently and works out well for everyone. And some of those details have not been fleshed out yet. We have not yet had situations where we've had to make differences, substantial difference in accommodation or secretarial sharing or those sorts of things. But the policy does contemplate in circumstances where it would be acceptable that might happen, that you might share an office, that you might share a secretary. It's that flexibility.
Yes?
Hi, I have a two-part question, and it's for people from Great Canadian and Mr. King as well. In your program, talking about part-time associate and part-time partner, in either of your written policies, do you include new associates coming into the firm, either of your firms accepting new associate on a part-time basis? Is there a minimum number of years that an associate has to work before a part-time policy can kick in? My other question is, you talked about being paid on a pro rata basis based on hours put in. Is that billable hours, or how exactly do you calculate that? I mean, if you have somebody that's hired full-time, they're given a salary based on their year on the call. Now, how do you do it with a part-time person? If somebody says, I'm putting in 60% of a full-time person a week, or coming in 3 full days a week, do you just put it as billable hours, or is that accepted? And same with you, Mr. King, when you say somebody comes in every morning or every afternoon, is that accepted, or are you just looking at the billable hours and deciding how to compensate?
Maybe I could start with Mr. King.
The first question is that we do not have any waiting period. It starts from day one. We have had occasions when pregnant women have come to us for employment and we've hired them, and then they've, in a few months, gone off for their maternity leave because they're very good. We want them, and we're willing to take them on that basis, understanding that this was going to happen right away. So far as its billable hours, we count as billable hours pro bono work, though that is not truly billable, but it is we count as not only pro bono work, but, for example, there are parts of the office that help other parts of the office, house closings, trust and estates work, and that kind of thing, where no bill is sent because they're doing it for other partners and associates. We count that as billable time.
So you have to keep it code.
Exactly.
I think my response would be precisely the same. In fact, we just took on a woman on a part-time basis that was lateraled in, and our approach to compensation would be the same.
If I could just add to that, I think it's sometimes found easier to hire somebody specifically for a part-time position than it is for somebody who has been on a full-time track to go part-time. And it's not really rational. It comes down to sort of human perception and the difficulty of one's colleagues adjusting to someone who's been there all the time, reducing their job responsibilities, and the difficulty of doing that.
Wonder if anyone has a question to direct to either Lynne or Paula or Lorraine? Yes?
I have a question for Lorraine. I don't know if it's necessarily a question that can be answered, but perhaps more of a comment. She was talking about modeling and the stereotypical ideal of what is the lawyer, what is the person like. She gave a number of characteristics which would generally be considered positive characteristics,
I think your point, your several points are very well taken. From what I can tell about these myths, they only work for men and against women. And the thing about the myths is that they're stronger than reality. People who are caught in these myths, or people who hold these myths, don't see the myths and don't see beyond them. So, and I think what you say is absolutely right. I think this idea of women who are running very complicated homes and their children's lives and carrying on law practices are exactly the kind of people who should be considered quite remarkable in their organizational skills, and yet this is held against them because they're distracted or whatever. So I think that it's a sword that only cuts one way, and it's too bad, although there are signs that it's changing.
Mary Jane?
This is also part comment and part question, and I think it's really directed probably to Paula and to Lorraine in terms of trying to, I think, probably follow up on what Lorraine's last comment was. In terms of what we've been talking about today, it seems to me that we've been actually going at this problem at two levels. One is essentially the level of the individual woman lawyer, the problems that a woman lawyer experiences simply because she is a woman lawyer, and how she might respond in particular situations to the situation she finds herself in, whether she acknowledges that she's in a stressful situation or whether she doesn't, and how she actually responds in a particular situation. And then at the other level, I think we've been looking at it in the context of more of the systematic, structural response of the legal profession as a whole, and in particular, the response of individual law firms. Although I think we do need to not lose sight of the fact that we're also talking about the government who hire lawyers in great numbers, especially women lawyers, corporations who hire women lawyers, and all kinds of other sort of non-governmental but non-private law firm people who occasionally hire lawyers as well. We shouldn't just be focusing on that. But when I start thinking about this sort of two-strategy way, how does the individual cope on one hand, and how does the system, how do we all, as members of the legal profession, try and make this a place where women and men are equally valued, equally encouraged, equally able to compete and succeed in a way that they feel some satisfaction. It seems to me that I end up coming back to the question of women lawyers, and although I'm a law teacher and don't practice law, I have peers who are partners in major law firms in Toronto, as well as sole practitioners across the province. And when I look at all of us, I see us all dealing with different problems, but still making choices that my male peers never have to bother making. Different choices, different sacrifices. And even though the choices we're making, and therefore the kinds of stresses we have, are quite different, we have more in common with each other than we do with my male peers who aren't making any of those choices or sacrifices. And I suppose what I have been trying to think about lately is how is it that we can, as women, support each other even when we are in very different places, so that the woman who is my peer, who's a partner, a middle-range partner now in a major law firm in Toronto, who have totally assimilated to the male model. In one case, she isn't married, and in every other case I know of, she doesn't have any children. So she has, in fact, been able to become that dynamic, long, hard-working person with no obvious family responsibilities. And she is succeeding. But she needs support, just as women who've made entirely different choices. And I think I'm drawn to something that Lorraine said right at the end. There should be ways for individuals to bring those problems in a constructive environment in which we can recognize the similarity within the difference without having to go to the Human Rights Commission, which, from my perspective, is not necessarily a wonderful way to go. It's not a bad way, and it's the only way I regret it. But it does seem to me that some intermediate level might in fact be appropriate here. And I was going to sort of put on the table, and then I'd like to hear from Paula and Lorraine in particular, but probably Nancy too knows how it is. I have a secret that I'm going to divulge
not naming any names. What do you think of that? I never say anything about my secret file, but I have a lot of information about what's going on in the recruitment process, and I can process that in a way that may be helpful to other women, some of them extremely bright and very much sought after by that firm, in a way that is in fact affecting the recruitment process in downtown Toronto. I wonder whether other law teachers are doing the same thing, systematically or ad hocery. And it seems to me that there are these certain kinds of things that we have in common. I guess it seems to me the Human Rights Commission is very public and a very difficult process in some ways in terms of what we're trying to achieve. And I think what I'm trying to think about is whether there are strategies that are somehow both constructive and also supportive of women. And I just wonder whether either Lorraine or Paula, or indeed anyone else on the panel, has even any thoughts again.
It's a good example of what could be informational social support, that file. Because the fact is, true. The fact is that what is supportive is partly knowing that other people are experiencing the same thing, but also expanding one's options about different ways of responding to it, so that people aren't operating in isolation. And when you have that kind of experience and knowledge available, then you obviously can mentor and advise in a better capacity. I think there's lots of evidence which would suggest that the way you're thinking is very valid, that in fact the important issue here is the support one, and that we have to expand our options. And really, I think women have more options. This is one place where men don't use and can't seek out support as easily as women can. And I would disagree with you that they're not making choices and sacrifices, because some of the studies about men who have become major executives, taken this route, and then children leave home, their marriage is a mess, and they're suddenly very depressed. You know, there's a whole lot of studies, and maybe at a different time, maybe for different reasons, but they have made sacrifices and they have lost out, and they do recognize it, at least large numbers of them do, and are at a loss about how to deal with it. It's easier for women to seek support and to use it, and we should take advantage of that in the professional as well as the personal, any way we can.
Lorraine, do you have a response?
Yeah, I think I could take about a day on this, but let me try to be briefer. One of the things that I found quite interesting, just because of the fact that I was the senior woman in the government for a long time. I was the only woman doing litigation when I was hired to do litigation in the government. And although there are many, many women in the government now, for a long time, I was the person who'd been doing it for the longest time, and eventually broke into the management level. One of the things that I think is quite a problem now is that there aren't senior women. I mean, I was really surprised in government how often other women would come to me and talk about problems they were having, conversations they had, perceptions they had as to how decisions were being made that impinged on gender, and how much, well, as Paula said, just talking about it really helps. Getting another dimension, getting more information from someone else who's known the person who has power, and being able to work out whether there's some sort of problem. So that in government, I found that I could fulfill that role. But of course, there was no one to fulfill that role for me. So as I mentioned earlier, when I ran into trouble, I really had no idea what was going on. And part of that is because you're very stupid when things are happening to you. I mean, you can be very smart when someone else brings in a problem and play with it and hypothesize, but you don't have as much of a sense, or I certainly don't, of how I present in the world. And I, of course, undervalue my contributions. I undervalue my complaints. I think I undervalue when people are being unfair to me. So that, in fact, I felt a tremendous need for a mentor, and I didn't have one. So I think that kind of mentoring and helping is very valuable, and that women seem to do it naturally with each other because we do have a culture that we share. I mean, whether it's by nature or by nurture, where we are socialized to talk about things that bother us and to try to understand the world around us verbally. So I think that my experience in government would lead me to respond in that way. In terms of the year I've had at the law school, I have just been astounded at my experience this year. First of all, I have office hours notionally from 11 to 12 on Tuesday and Thursday. Very often on Tuesday and Thursday, I don't close my office door till 5:30. I mean, it's sort of a joke to some of my colleagues. Now, some people laugh at this and say, "Oh, Lorraine, you're so maternal. The students love you," you know. And actually, I think that that's quite a nasty thing to say all around. It took me a while to realize that. But what the students are bringing me is actually very, very interesting. First of all, a lot of them aren't my students. In the first couple of months of the law school year, the first year program includes what's called a bridge period. And what it means is the first year students stop taking their regular courses and they take a course that's a perspective on law course. This year we took a bridge period on feminist perspectives on law. So I was exposed to all the first year law students. And through the year, an enormous number of those people have come to me with various problems, and also, I must say, a lot of upper year students whom I do not teach, with problems in the school about gender. And they come in to talk about what they should do. There's no formal mechanism in the law school to deal with gender issues. And it's wonderful to see that these students just grow visibly in the office when you talk about these issues. And of course, the issues aren't owned just by women. There are a lot of men who are very perturbed about these issues. Indeed, I've had a number of men come into me and complain about the fact that a lot of women think that there are no problems remaining on the gender issue. So that's a response to this question about what about the men. And to some degree, there are a lot of men out there who are much more sensitive than women are. But the interesting thing, I think, is that just by talking, just by sharing experiences, by analyzing the problem, by suggesting from one's own experience or from what one has read what can be done, one can empower women to do what has to be done. And women have done amazing things this year in confronting professors with problems and in turning the table around, even though the power structure lies very much against them. So there are all sorts of things that can be done, and I'm very heartened that just with a little bit of a mechanism, women can do something, but we need much, much more. And I think your secret file shouldn't be secret. I think that every person, male and female, who goes into these recruitment situations and has one of these remarks made, whether it's a remark about religion or race or gender or whatever, should have a form that they have with them, which has been authorized by all the law deans, and write down whatever it is and have the interviewer sign it. That's all we have to do. That's all but the problem is, of course, all of this hatred and prejudice will just go underground. But in a way, that's okay, because if you can't say to people, don't think about a corporate career here because we don't let women do it. If they can't say it, it makes it harder for them to do it. But I think what's going on in the recruitment process is just a scandal. I mean, lawyers actually think that the Human Rights Code doesn't apply to them. And as for the nastiness, maybe that's where the nastiness comes from. If you think the Human Rights Code doesn't apply to you, you think a lot of other things don't apply to you in terms of civility.
There was a comment at the back that I think follows up on this.
No, it was more a question. I'm perhaps coming from a quite different perspective than the other people here because I come from a small law firm, a small partnership. And I haven't heard any of our concerns addressed today. And many women chose to go into small partnerships because they felt it offered them more flexibility, it gave them more opportunity to come up with an appropriate plan to balance their private lives with their business lives. And yet, when you're in a small firm of 3 or 4 lawyers and trying to provide a general practice, but each tending to specialize in an area, you are in a much more difficult position. The partner really feels they can't possibly take any significant time off. I've got a partner right now who was supposed to deliver on Monday, and I couldn't be sat down here today until we saw the baby had arrived. And she is intending to take maybe 2 or 3 days off work because she's the only one in the firm that can handle real estate law. None of the residents would touch it. And, what do you do when you're a small firm? What kind of accommodations? I mean, we talked about how you can do it in a firm that's got 100 people, 1,000 people. Well, what do you do when you only have 3 or 4 people? I mean, how can those problems be addressed? And no one
ask Lynne Sullivan if maybe she could try to respond to that.
Because I'm the least dangerous person.
No, because you seem to know the most about workplace arrangements.
Well, I can tell you what an employer in another circumstance would do, and that is simply to make an affiliation with another body or person who would provide the service. So in other words, to cover it off I mean, the one thing about babies, maybe they're inconvenient and they certainly arrive when they feel like it, but you know within a tolerance of a few weeks when the baby is going to arrive. And in another organization, they would make a formal arrangement, either a contractual arrangement or a subcontracting arrangement with someone else to provide the service. Now that could be a problem in a small location where you couldn't find somebody else to cover it off. But I think at least in that circumstance, you've got enough notice that, you know, that you could do something like that. And other than that, I sympathize with your problem, because one of the advantages of being with a big as opposed to a small consulting firm is that in fact you might work longer hours at sometimes, but you have a lot more flexibility about what you do and when you work.
Mr. King, this is really peculiar, I'm noticing I'm calling everybody by their first name except you, and I keep referring to you as Mr. King. Henry is going to leave in a few moments because he has a flight to catch back to New York, so I thought I might invite any of you who have questions to address to him to put them now. Yes?
Well, we've heard from the representatives from large firms about the large numbers of women that will be coming up to the partnership and also maternity leave in the near future. I was wondering how those firms are going to plan for that, because that would be a different situation than they've had to deal with in the past.
Having women partners doesn't require any planning. I mean, they're partners for all purposes. I think the fact that we have had for a number of years now part-time work for associates, it's worked. I don't think we're going to get any more or a larger percentage of women doing this. I think there's very little planning that has to be done, except that I think it's working from the standpoint of the firm, and it's working from the standpoint of the woman reasonably well. As I said before, it's not perfect, but I don't think it requires much planning at this stage, even with the numbers involved.
I took the question to mean that as the large numbers of women come into your ranks, that there may be some dislocation, but is your answer, excuse me, that you don't anticipate there will be?
I do not.
I think there was another question. Yes?
Just, it's an observation, and I just wonder if there's anything developing that I'm not aware of, but it seems to me that the hours lawyers are working generally are really running out of control. And that's male and female. And part of the problem women are having with the profession is not what would normally be considered normal hours, but what lawyers consider normal hours, which I think by anybody's standards are pretty abnormal hours. And I'm wondering if you're feeling at the firms, big firms, or elsewhere, not just a dissatisfaction with women in that they want to work part-time, they want accommodation, which perhaps they might not even need if the hours were normal. But because even when you look at your 60% of what your hours are, that's a pretty stiff week. But whether you're feeling a dissatisfaction generally from men and women, that there's an awful lot of working hours and there's not a lot of time to spend with your families or on with your own interests, so that you're seeing a dissatisfaction with law, because you can make a lot of money, but you die and you don't have time to spend it. Enjoy it.
And I wonder, Mr. King, before you respond to that, if you could just give everyone an idea of what someone in your firm, or how someone in your firm might have to work in order to achieve the 2,000 billable hours that you expect.
To achieve 2,000 hours, you have to be in the office or working at something at least 2,200 hours and probably closer to 2,400 hours. There's just a certain amount of lost time, and if you're recording your time accurately and fairly to the client, you're going to lose about 10%, roughly 10 to 15%. So you have to work very hard to get 2,000 hours. We do not, in our firm, have any bogey where we require a certain number of hours. And as I said before, on the average, our associates work about 2,000 billable. It turns out that our partners work about 1,800 hours billable. Now, I'd like to comment a little bit on, I think it's not so much the long hours, although they're certainly there, as the quality of the hours has changed over years. There's more stress, there are more deadlines, there are more merger and acquisition transactions. It's got to get done. There's more pressure from the courts to get your papers out. Your opponents don't give you the time that they used to be able to give you, and the quality of the hours are different. Law has always been a tough profession. My father was a lawyer in a 3-person firm. Now, he didn't keep hours. He was a trial lawyer and did a lot of accident work, negligence work. He came home at night and went out almost every single night. He was hustling for business. Now, that wasn't billable hours, but I can tell you that he worked extremely hard. In going around New York State, in my capacity in the Bar Association, I see lawyers in small firms working just every bit as hard as lawyers in big firms. The hours are there, and it has always been the case. And when I started in my firm roughly 30 years ago, I worked every bit as hard as the young lawyers are working today. I do think, though, what I said before is true. The quality of those hours have become tougher on people today than it was. Part of it is the lack of civility. You can't get extensions of time so easily. The courts are pressed. They're understaffed. The deals are bigger and more important, and they've got to get done. The deadlines are there. And so it is that aspect of it, I think, that makes it harder. It's not the total hours, in my view. No, she didn't.
She did, but if she didn't, now what you're finding is that in many professional men are married to a professional women or otherwise working women. And more of the burdens of life are shared, although not nearly as much as women I think would like to see them share. But the men don't have as much time to end. I mean, I look at my father. My father, he worked, he came home, and he didn't do what I see a lot of men my age wanting to do with their children and making the effort to do. It wasn't the norm for them, but it is becoming something that men as well want to do, have that quality time with their children and with their spouse, and they too are deprived.
There's been some disgruntlement, I have to say, though lawyers are very competitive, and I think the people who are attracted to the larger firms in New York City are motivated in a way that is extraordinary, and they're willing to work. We don't tie them down to the chairs. We really don't, and we do not require a minimum, and we don't keep records of on an individual basis, so that we don't confront them in their evaluations. Well, you only worked 1,800 hours, and the average is 2,000. We simply don't do that.
You, I think, have to go.
I do.
Okay. We may have time for a couple more questions, but I'd like you to join with me in thanking Henry King for being with us today.
Thank you very much.
I'm just wondering if I could get the rest of my question answered by what's happening in Toronto.
Yeah, I'd like to respond to that. Certainly, the norms in Toronto are not at what they are in New York City at the present time. At least, I think generally speaking, there are some firms that are demanding norms that are comparable, but by and large they're not, and certainly our firm is not. But I'm very conscious of the dilemma that you're talking about. And my sense is that we're driven to increased hours by economics, and a lot of that economics has to do with where we choose to practice law and the way we try to practice law. And if I were to express a personal opinion, I guess I'd be in favor of some sort of a trade-off there that would allow male and female solicitors, lawyers, to have a lifestyle and balance it with their life as lawyers. And part of that trade-off is deciding, as some firms are, to develop offices in areas, in the suburban areas of the city where you don't have the high rental rates that drive, to a large extent, your necessity to have higher incomes. There are options there, and expressing a personal view, I think we should look at that. I also feel that it will be easier to address those issues when there are more women in the profession, because I subscribe to the notion that's been suggested around here that women do bring to the legal table qualities that men don't, in terms of civility, in terms of being able to understand and make those trade-offs. I think their models are somewhat different from the men, and I think that is going to produce a better functioning law firm and perhaps take some of the stress, because there are very high stress levels, as Henry has alluded to, and I think that has grown beyond the hours put into it. And I'd like to just, because I've been trying to contemplate the other issue that was quite plainly raised, and I think legitimately raised, what are we as managers and lawyers in the profession doing about educating the men, or socializing the men here, and I think that is an agenda item that has been missing, and it's a difficult one to address. One of the reasons I'm happy with the suggestion in the report we made to the firm about having an oversight was that we would be required once a year to engage in a dialogue that would educate the men in the firm about the problems and increase their awareness and understanding. We need to find ways of doing that. It was helpful when we had senior role mentors, models in the firm, and some of the firms don't have those at the present time. Yes, sorry.
It's 5:30. Perhaps what we'll do is take one last question, and then any of you who wish to stay and chat informally with our panel can do so, and that way those who are anxious to go home may leave.
I have a question for you, Nancy. You mentioned in your recommendation the question of the mentor. Did you come forth with any recommendations about mentors to your firm?
Not really. I mean, we simply identified it as a problem. Bruce has just alluded to the fact that our firm did have, we had Madam Justice McKinley, who was a senior partner at Fraser and Beattie when she was appointed to the bench. We lost her as a senior mentor, unhappily, and I think, you know, all that we can really do about that is make sure that the women who are at the middle range partnership level now have an environment sufficiently conducive to the competing goals in their life that they manage to stick it out until they reach the senior level. And overall, that was what our report was trying to accomplish.
On another issue that you mentioned, that was mentioned earlier on the Cushman daycare. Do you or do any firms you know buy into a daycare program where you provide spaces for female employees?
I'm not aware of any that do. That's one of the things we've talked about doing in terms of an emergency backup situation, but we haven't yet followed through on that.
Well, on behalf of all of you, I'd like to thank each of our participants for being with us here today, and I hope you'll go back to your firms or to your organizations and talk about some of the issues that we've discussed, and we look forward to seeing you at Women in the Legal Profession Part 3. Maybe that will be the last time that we'll have to hold this program, I say optimistically. I think the panelists will stay around for a few minutes if any of you have any individual questions you'd like to address. Thank you very much for being here.